Today's the second day of jury deliberations in the Aaron Thomas trial. They deliberated for about 2 hours yesterday afternoon. Is there any way in trials that are this long? We had 17 days of testimony, 19 days, including opening and closings, and 25 different witnesses. Is it easy to tell how long that's going to take for a jury to come to a verdict?
It's almost impossible to tell how long it's going to take the jury to deliberate. I'd anticipate it's going to be a number of days. They have a lot of testimony that they have to rifle through, a lot of things that they need to consider, and any one of those things could hold them up if they can't come to an agreement on it. So it's really difficult to determine how long the jury's going to be out or read into which way they're leaning based on how long they've been out.
Something unique about this case is that we saw the defendant, Aaron Thomas, take the stand for 5 different days. He testified in his own defense, and he actually admitted on the stand, hey, this was inappropriate. I'm sorry for some of the things that I did, but it wasn't criminal. How common or uncommon is that to see?
It's fairly uncommon for a defendant to take the stand. You have an absolute right not to take the stand in your own defense, and the judge will instruct a jury that they're not to consider a defendant's failure to testify in any way during their deliberations. So the burden's not on him to prove anything. He doesn't have to take the stand. In this case, he chose to, in large part because there were a lot of things that he needed to explain to this jury. There's a lot of testimony against him coming from former students saying that he was aroused during these fat tests, and other experts coming in and saying that there's just no justification for the students to be naked during these things. So he needs to get up there and explain why for 28 years he was engaging in this type of behavior.
Do you think it hurts him that he is apologizing on the stand and acknowledging that aspects of this were wrong?
I think it probably helps him. And I think that was a strategic decision made by his defense attorneys, who are both very skilled and experienced, to put him on the stand, take ownership of what he did, but also say that this was not criminal because it wasn't for the purposes of sexual gratification or arousal. And that's the key point that they needed to get out from him during his testimony.
When it comes to that point, how do you prove whether something was for sexual gratification or arousal? We had one student who was very emotional on the stand saying, I know what I saw. I know that he was aroused during this testing. He says, no, I wasn't. But it seems to just be one person's word versus another. Is that something that's easy to prove?
It can be very difficult to prove because you can't get in someone's head. You don't know if he's doing it for that purpose. So you have to look at circumstantial evidence around what's going on and make a determination that way, as far as, was this for the purposes of sexual arousal or gratification, or was it for something legitimate? So very hard to prove. Need to look at the circumstances surrounding it, and that's how the jury is asked to make that determination.
The jury, in their verdict form, is also given the option, if they find him not guilty of these felony second-degree child molestation, felony second-degree sexual assault charges, that they can consider a misdemeanor battery charge, which would have a less things that you have to prove. They wouldn't have to prove that sexual arousal gratification part for that. When it comes to those lesser included charges, I guess, what is your take on that? Does that make it easier for the jury to come to decision, or does that just add an extra wrinkle for them?
It can. You can end up in a situation where the jury's split. They don't know where to come down, a straight not guilty, or was this touching offensive? Even if it wasn't for sexual gratification, was it just offensive and unwanted on the part of the victim? In that situation, they can come back with the lesser included charge with the battery, which wouldn't carry as high penalties or other consequences for the defendant in that situation.
Another unique thing about this trial is that about halfway through, in the middle, the judge experienced a family emergency. And there were some unavoidable circumstances where for a week and a half, the trial was put on pause. So there was a bit of a gap between the jury hearing the testimony of these former students who were very emotional on the stand, and the defense actually presenting their case and Aaron Thomas taking the stand. What kind of impact could that have on jury deliberations when it's been a longer time since they've heard from these prosecution witnesses?
I think that can have an effect if the jury heard some very intriguing testimony, and they're left to ruminate on that for a period of a week and a half. And that's all that they are thinking about before the defense can come back and rebut that in any way. That's going to stick in their minds, and probably more so than had they immediately heard from the defense after that testimony. So it could hurt the defense in that way.